Oh, hey guys, hello. I hope you're all doing really well. Today's the day we've all been waiting for. Wayfarer have filed their response to the absolutely ludicrous request for fees from Lively, and I have high expectations for this. I haven't read it yet, but I have really, really high expectations for this, and it's not too long. The brief is only 16 pages. There are a lot of attachments and a declaration and everything. Which I might peruse rather than read in any great depth. But let's start with this declaration. And let's see, it's a great moment to kind of see, like Wayfarer's arguments here. Okay. So let's go past table of authorities. Introduction. This is anything but a typical fee motion. All right, now I get a sense of how this is going to pan out. Pursuant to California Civil Code Section 47.1, Lively claims that she is entitled to a stunning $7,495,526 in attorney's fees for 7,070.20 hours billed by no fewer than 82 timekeepers to obtain the dismissal of a single defamation claim at the pleading stage. I mean, when you put it like that, it's incredibly reasonable. But this is what I was saying. Like in my video, when I was going through this, and I know other content creators have done similar things, like peeling off certain lines of, well, what the hell has that got to do? Like, why are you claiming for fees for researching and responding to a motion for judgment on the pleadings against your claims, not defending someone else's claims, which is not the point of Section 47.1. Why are you claiming fees for researching perjury into whether you perjured yourself, or responding, or reading, Brett McDowell's motion to intervene? It was absolutely nonsensical. But I did also calculate some of the hours as well, and I was like, that's just wild. How can you spend this much time on a motion to dismiss? I didn't understand it at all. Like, it seemed, like, if they needed that much time to do that much research, did they really know what they were doing? Because you pay attorneys to do this stuff for you because of their knowledge. So how did they need to do so much research and so much strategizing? It was batshit. I mean, the claims themselves were not overly complicated, except for maybe Section 47.1, because there was no precedent and it was a case of first impression. But individually, each of those claims, both on the affirmative and the offence, both affirmative and counter in the counterclaim, would have been something, they individually, like, the lawyers know about defamation, they know about civil conspiracy, they know about intentional infliction of emotional distress, they know about all of this stuff. It looked complicated because there were multiple of them in each complaint, and there were multiple defendants / plaintiffs. So that was the only thing. But again, these attorneys were specifically picked because they were quote unquote experts and leading law firms in complex litigation, yet the amount of research they needed to do for each and everything was telling me that they were struggling and their knowledge wasn't that good. Anyway, that was my soapbox moment. That was quite early, wasn't it? I'm sure I'll have more. So anyway, yeah, so she is saying, so Ellen is basically saying, look, you want nearly 7.5 million in attorney's fees for over 7,000 hours of work, which has been billed by no fewer than over 80 timekeepers. And the timekeepers, when she says timekeepers, she's talking not just about the attorneys at various levels. Like, so you've got your partners, you've got senior associates, you've got associates, junior associates, you've got some of them will include trainees, and then you've got other people as well, like your paralegals. You got your research assistants. You'll have secretaries. Various admin staff. It'll be like a lot of people. There'll be a lot of people. A lot of this work was done by, especially the research that should have been done by paralegals predominantly, not, Michael Gottlieb at nearly $3,000 an hour. And definitely he should not be researching extensively defamation claim. He should know that. It's like one of the most common claims he's going to have dealt with in his career. Anyway. So yeah, she starts out really, really strongly, pointing out the ridiculousness of the work that they're claiming went into, dismissing a single defamation claim at the pleading stage as well. It's not even like, at the summary judgment stage, which is further down the road after discovery. It's at the pleading stage. So when the earliest stage possible. Okay. In contrast, the New York Times is seeking $181,000 in a fee request filed in a state court for its motion to dismiss precisely the same defamation claim. Of course, Lively could not possibly have spent over 7,000 hours preparing the portion of the same motion to dismiss directed to Wayfarer's defamation claim. Rather, to arrive at this extraordinary sum, Lively broadly construes Section 47.1 to cover not only reasonable fees for work necessary to defend Wayfarer's defamation claim, but fees for work on directed to it's a typo. Fees for work directed to Wayfarer's 8 non-defamation claims and Lively's 15 affirmative claims, which Lively characterizes as inextricably intertwined. However, Lively's affirmative claims, including those for sexual harassment, were unsuccessful, either dismissed on summary judgment or voluntarily, and she was therefore not entitled to fees under FEHA or Title VII. Lively, nevertheless, now seeks to recover such fees under the guise of Section 47.1. Lively's fee request is so over-inclusive that it sweeps in fees for researching her own liability for perjury arising from her California CRD claim and her Rule 11 motion, for which the court has already denied fees. And I know Bocci, I believe Bocci pointed out the California CRD perjury claim. I don't know if that came from somewhere else. I was made aware that Bocci had pointed that out. I pointed out the Rule 11 motion and that the fees had already been denied there. Wayfarer will have known this. It's not, we're not discovering things that they will not have seen themselves. But it's good. It's lovely to see when we're kind of right about things, when we're, following the right threads. A fee request that appears unreasonably inflated is a special circumstance permitting the trial court to reduce the award or deny one altogether. This is just such a case. Okay, so this is going to be good, I think. Okay. Lively's... Oh, hold on, let me just move this. Right, Lively's fee request lacks the requisite evidentiary support. Yeah, there was no invoices. It was just some woman who is not an attorney or anything, has any experience of fees or fee shifting, or even, well, especially Section 47.1 fee requests, just basically put together a spreadsheet and said, trust me. So, the starting point is to calculate the lodestar by multiplying reasonable hours by a reasonable hourly rate. The court then has discretion to exclude time that is excessive, redundant, or otherwise unnecessary. Even where fees are mandatory, the court has broad discretion to adjust the fee downward or deny an unreasonable fee altogether. The fee applicant bears the burden to prove reasonable rates and hours, and inadequate documentation requires a reduction. Lively does not provide billing statements or other records to support her $7.5 million demand, much less allocate fees to her defence of Wayfarer's defamation claim. Instead, she relies on summaries prepared by financial analyst Diana Kantner that place fees into three buckets. 1. Fees relating exclusively to the Wayfarer action, i.e., defensive costs. 2. Fees relating exclusively to the lively action, i.e., offensive costs. And 3. Fees relating to both actions, i.e., intertwined. Lively seeks $2,267,288.75 for defensive costs and $5,228,238.12 for inextricably intertwined defensive and offensive work. Kantner's submission deserves limited, if any, weight. Her views on reasonableness reach the ultimate issue and are inadmissible. Okay, so Kantner is not an attorney or fee expert, but a consultant on insurance recovery and litigation support and data analytics. Her experience with legal fees is limited to several occasions on which she served as an attorney fee expert, including some large and complex matters. Kantner does not include that she has experience or expertise in evaluating the reasonableness of rates or hours worked, fee matters relating to employment, sexual harassment, or defamation claims, or apportionment of fees under Section 47.1 or any other fee shifting statute. And this is really good. They got to obviously discredit Kantner and say, Judge, like they do with any other expert, you should not be listening to this expert because they haven't actually said that they know what they're talking about. There's no proof of that. Kantner does not disclose the methodology she applied to segregate work as recoverable, non-recoverable, or inextricably intertwined, or indicate that she reviewed the underlying pleadings or evidence in the Wayfarer or Lively actions, or is familiar with the facts giving rise to the parties' competing claims. Kantner is fuzzy. I love that word. Kantner is fuzzy on whether she provided with and reviewed original invoices and appears to have relied upon spreadsheets provided to her by counsel, which allegedly reflect the same information provided in the monthly invoices prepared for Miss Lively. She admittedly edited descriptions of work to excise privilege and confidential information without demonstrating the experience or expertise to identify such material, which is a really good, really fair point. Because I do believe that a lot of the stuff, especially stuff that pertains to Rule 11 in there, where they've got XX, I know like there's some stuff when they're talking about statements, research attorney statements and so on and so forth, and they're talking about Rule 11 sanctions, that they got, like, say for instance, BF for Brian Friedman, because he's the one that made the statements. They made such a song and dance about it, they left us in no doubt who that is. But I do think that there are other redactions that refer to Ryan Reynolds, and like, how does she know how to redact? Because sometimes where it's clearly obvious it's Reynolds, the name has been redacted for those two X's, but then there's other times where the name, whether that's a mistake or an oversight, that the name's not been redacted. And I think kind of, Wayfarer do actually pick up on that a little bit, because then they go on to say many edits appear haphazard or arbitrary, with some ending mid-sentence. Kantner does not disclose the basis for her decisions to edit or delete certain entries, or whether they were dictated by counsel. Wilkie and Manat did not verify the accuracy of the underlying invoices, the spreadsheets provided to Kantner, or Kantner's summaries or calculations. Kantner's declaration and summaries lack foundation and should be discounted. Oh, that's true, actually. Yeah, that's a really good point. Wilkie and Manat did not actually verify the accuracy at all. Okay. Wilkie and Manat's hourly rates are excessive. A reasonable rate is a reasonable client. Well, Lively's anything but a reasonable client. A reasonable rate is one a reasonable client would pay to litigate the matter effectively while spending no more than necessary measured against prevailing rates in the community for similar services by lawyers of reasonably comparable skill, experience, and reputation. While an attorney's customary billing rate and fee arrangement with the client may indicate a reasonable rate, the client's agreement to pay an expensive rate does not mean that the rate is reasonable and may be imposed on an opposing party. And that's Lyman's own ruling. Biographical information is required for the court to evaluate the reasonableness of an attorney's billing rate, and courts generally deny requests that lack information on a billing attorney's credentials. Okay, so then they cite Zero Carbon Holdings, rejecting fees for time billed by lawyers without information on their credentials, noting that where the applicant fails to provide even the most basic information necessary to assess the reasonableness of rates, such as years and type of experience, courts generally reduce fee requests. They also, now this is going to be fun. They also cite another case, PDV USA, a case which was decided on May the 11th, 2026. So that's this year, where specifically in that case, they reduced Wilkie's fee, that's Gottlieb's firm, they reduced Wilkie's fee request by 30%, 15% of which was for rates and 15% for hours, for failure to provide evidence necessary to assess their reasonableness. And then specifically, they reduced Gottlieb's 2026 rate to $1,677.90 in a complex commercial matter. So this is a case that is literally only 2 months old, and they have, a fee request was heavily reduced, to reduce a fee request by 30%, and to then literally half Gottlieb's hourly rate is quite a thing. I love that they've cited that as well. If nothing else, it's not only is it persuasive for Lyman, but it's like it's entertaining for us. Because obviously this is not the first time that Gottlieb and his firm have done this. And we all kind of speculated quite a bit, I think, on his hourly rate versus Ezra Hudson's, who is a comparable attorney. Now, I think you can give some weight that New York, like London, has, higher rates of charging fees compared to, the rest of the country, or certainly other areas of the country. In London, we have London Waiting, which just adds on, an additional amount compared to other areas of the UK, because of the cost of living in London. Maybe New York has something very similar, but he was excessively, like nearly £1,000 more per hour than Ezra Hudson, which was wild. Okay. Lively recognizes that the reasonableness requires an assessment of each lawyer's expertise and experience, yet fails to provide biographical information for 71 of the 82 timekeepers. The $2,480,100 in fees billed by timekeepers without biographical information should be deducted from Lively's fee request. I agree. Further, the hourly rates sought by Lively exceed the range typically approved in this district, requiring a reduction of the rates of the 11 other timekeepers. So, and they cite Greyhawk, Hawthorne Lender, a case from July last year. Hourly rates in district for experienced litigation partners are between $500 and $800. And then there's the case of Aletson, where they reduced associate rates by 30% and capped law clerk and paralegal rates at $250 an hour. Lively fails to apportion non-recoverable and recoverable fees. Lively contends that Section 47.1 entitles her to recover fees and costs on both defensive and offensive work that is inextricably intertwined among her successful defence of the Wayfarer action and her unsuccessful prosecution of the Lively action. Fees are generally recoverable only with respect to the claims subject to fee shifting. Hensley provides that a prevailing defendant in any defamation action brought against that defendant for making a communication that is privileged under this section shall be entitled to their reasonable attorney's fees and costs for successfully defending themselves in the litigation. Only Lively's defence of count 2 of the Wayfarer complaint is subject to fee shifting under section 47.1. Lively first argues that section 47.1 entitles her to fees incurred for the entire defence of the Wayfarer action based on the use of the term in the litigation. In the litigation, however, must be read with its antecedent prevailing defendant in any defamation action. Absolutely, it is quite specific. It is quite specific. I said this in my video as well when I pulled up the statute. Like, no, you can't. It does not leave open that, you know, it might include all of the litigation, because it specifically it specifically allows prevailment on the defamation action. So you cannot then claim for, you know, the fees for a victory in the entire litigation. That's just ridiculous. That's a stupid way of looking at it. I appreciate Lively's attorneys, you know, trying it on a bit, but that was never going to hold water. Lively cites no authority for the proposition that Section 47.1 is any broader and converts every claim into a multi-count complaint or every defence of every co-defendant into recoverable work. Absolutely. And, you know, again, they cite another case. Defendant may recover fees and costs only for the motion to strike, not the entire litigation. Lively also seeks to exponentially multiply her fees on the ruse that her defence of Wayfarer's 8 non-defamation claims and the prosecution of the 15 affirmative claims asserted in the Lively action are inextricably intertwined with fees expended to defend against Wayfarer's defamation claim. Lively begins with the remarkable statement that the court is not permitted to apportion the allegedly intertwined claims. It kind of is. Lively is wrong. Fees need not be apportioned when incurred for representation on an issue common to both a cause of action in which fees are proper and one in which they are not allowed. However, a court may apportion fees even where the issues are connected, related, or intertwined. So they cite plenty of case law for that. The moving party bears the burden to show that the claims are inextricably intertwined. Inextricably intertwined does not mean merely related. Rather, the issues are so interrelated that it would have been impossible to separate them into claims for which fees are properly awarded and claims for which they are not. Lively does not identify any issue common to Wayfarer's defamation claim that would have been impossible to isolate. Nor does Lively explain why her billing records combine fees billed in both the Lively and Wayfarer actions without any distinction. Lively's counsel billed work concerning 47.1 fees, damages, and procedural mechanisms in connection with her motion to dismiss, filed in March 2025. Yes, the judge. Yes, that's right. Yes. Yet knowing Lively would be submitting additional briefings seeking fees under section 47.1 for the defence of Wayfarer's defamation claim, counsel continued to block bill with no effort to apportion fees between claims. That's a really bloody good point. Love it. Lively should not be allowed to saddle Wayfarer with millions in fees based on her own failure to properly allocate billing. Yes. I love that argument. I really do. Further, Section 47.1 applies to the defence of a defamation claim and liably provides no authority for the notion that it can be extended to the prosecution of affirmative claims. This court has held that in general a party cannot recover its legal expenses for prosecuting a counterclaim or third-party claim. The principle on which liably relies, that fees are recoverable because her affirmative claims are inextricably intertwined with her defence of Wayfarer's defamation claim, applies only where the claims are a mirror image of each other, which requires more than common facts and related theories. Yes. Courts also consider the relative degree of success in obtaining results. A reduced fee award is appropriate if the relief, however significant, is limited in comparison to the scope of the litigation as a whole. Defamation I'm losing my voice. Defamation was one of 9 claims attacked in Lively's motion to dismiss. Lively asserted 15 affirmative claims against 10 defendants, including 7 claims based on FEHA and Title VII. Lively cannot bootstrap a claim for fees on her failed on her failed what? I think there's a word missing there. Cannot bootstrap a claim for fees on her failed it then goes on to say did not prevail. I guess that's failed claims which did not prevail on her FEHA and Title VII claims. Yeah, typos there. Failed FEHA and Title VII claims into a claim for fees available for her defence of a Wayfarer's defamation claim. Lively also seeks fees for her Rule 11 and other sanctions motions, even though those motions were collateral to the defamation case defence, and the court declined to award fees for the Rule 11 motions. The record does not support a wholesale award of the both matters category. The court should exclude, or at the very least substantially reduce, the $5,228,238.12 billed for both matters and time not tied to defending the defamation claim. Other reductions apply. The court must reduce excessive, redundant, or otherwise unnecessary hours. Courts also consider whether the case was overstaffed. Yes. How much time the attorney spent on particular claims. Yes. And whether the hours were reasonably expended. Yes. Which all three of those applied here. Simultaneous representation by multiple firms poses substantial risks of task padding, overconferencing, attorney stacking with multiple attendants at hearings, and excessive research. And there's a case there, Donahue. Just as there can be too many cooks in the kitchen, there can be too many lawyers on a case. The most cursory review of Lively's submission shows multiple lawyers at the same hearings, numerous charges for lawyers conferencing, conferring, or strategizing with one another, and to put it mildly, extremely excessive research and online investigation. Ellen's basically saying, Your Honor, her lawyers are thick. They needed to do a lot of research and online investigation into what are basically bog standard, fresh out of law school claims. A lot of them are. Especially defamation. Defamation is it's one of the most commonly litigated claims. The court should deny or drastically reduce Lively's fee request to eliminate costs attributable to the overstaffing of this employment matter. 19 attorneys for representing one client at a hearing was just, above and beyond stupid. Lively's request for 7,070 hours, I'm just going to say that. 7,070.20 hours of work is 20 times the number of hours courts have found reasonable in defending similar high-profile defamation actions, even those with complicated and underdeveloped legal questions. Yeah. In Re Johns Manville Corp., the court reduced Wilkie's. So it's another case where Wilkie specifically had their fees reduced. The court reduced Wilkie's requested $543,165.70 in fees to $10,000 and $10,512.50 after finding the request unreasonable, where Wilkie billed 476.6 hours to prosecute a contempt motion co-counsel handled reasonably in 14.5 hours. The same type of opaque, overstaffed presentation warrants a substantial reduction here. So there seems to be a bit of a pattern with Wilkie. Oh, excellent. I think they're about to pick up on the point I was trying to hammer home as well. Right, so, relatedly, a prevailing party represented by the same counsel as a party not entitled to fees may recover only reasonable fees incurred in that party's own defence. So, they then cite multiple claims, actually, where the gist is an applicant must allocate fees it incurred between its defence of the claim for which fees are available and the defence of a jointly represented party. And I said, my whole theory is they're going to stuff, because they represented both Lively and Reynolds. It is not difficult. I'm not saying, and I'm not accusing anyone of doing this, by the way, it is, but if they were going to try and hide fees, they have a very easy way of doing that by, kind of not separating out Lively and Reynolds, right? Because they both had motions to dismiss filed by the same law firms. They both had Rule 11 sanctions filed, and there was a lot of Rule 11 sanctions fees that they're seeking to recover. Like, there were literally, I think I showed it in one of my videos. It was pages and pages and pages and pages just dedicated to Rule 11. There was more Rule 11 fees than Section 47.1. So they did that for both Lively and Reynolds. And I was like, they're spending an awful lot of time on these Rule 11 sanctions for just Lively. I firmly believe that they also had some of Reynolds' fees in there, because it wouldn't have been difficult to just push them in. And, if you're redacting information about, like under attorney privilege and work product, then how are you able to tell? How is anyone able to tell other than to say that's excessive? But it looks like Wayfarer picked up on that too. So they go on to say, Lively does not allocate fees between Lively and Reynolds, even failing to separate fees attributable to Reynolds' separate motion to dismiss. Kantner's summaries also reflect fees relating to the allegations against Sloan and the Times. Yes. All third-party fees should be eliminated from any award. Reductions may apply for vague entries, block billing, duplication, excessive staffing, unrelated work, and work that should have been performed by more junior professionals. I mean, the amount of times I saw entries from Gottlieb, right, who charges by far and away the most per hour, just, with just simply attention to, Rule 11, attention to Section 47.1. What does attention mean? What are you actually doing? Are you having a meet and confer? Are you doing some research? Are you drafting something for the docket? Like, what? But a lot of his entries just say attention to. And I think there was another one as well, Kirsten Bender. She also did a lot of entries which were just attention to, then insert here whatever subject matter we're talking about. But I have no idea what attention to means. Like, what would that even mean? Because that's not, that's not any kind of breakdown of what you are doing for your money. It's not explained to the client either. In fairness to Lively, it does not tell Lively what her attorneys are doing on her case that they are then going to bill her for. And I just think, I've lost a lot of respect for Wilkie. I didn't have much to start with because I've done videos on their past scandals too. But I did lose quite a bit of respect, like when I looked at that and I thought, it feels like they're stitching up their own client. And then in the hope that they're going to just claim this all back and Lyman's going to wave it through. And I don't think he's going to. All right. Da, da, da. Okay. Yeah, so they then cite a bunch of cases. There's Gonzalez, where descriptions such as strategize, internal correspondence, status and strategy conference, and attention to emails are impermissibly vague. There's Kearney. Fees will not be allowed for entries like prepare motion to dismiss and research and analyze legal defenses because they are exceedingly vague. In Ellison, for instance, the court identified block billing vague entries, disproportionate post-award work, and duplicative associate time, and imposed a 30% reduction in hours. The records reflect extensive internal conferences, overlapping review, and parallel work streams across firms. A percentage reduction may be used as a practical means of trimming fat from a fee application. Time entries for work on non-defamation claims include discovery, media statements, reports and appearances, social media tagging, digital campaign fact gathering, damages experts and punitive damages. Those entries are not self-evidently defensive of the defamation claim against Miss Lively. The court should exclude, without limitation, fees for non-defamation claims works for other Lively side defendants, and post-dismissal work other than the fee motion, reduce the claimed rates, trim excessive and duplicative hours, disallow unrecoverable expenses, and require any request for later invoice fees to be made by a separate supported application. Finally, plaintiff may not recover fees on fees, i.e., the time spent litigating plaintiff's fee application, which are only available when permitted by the unmistakably clear terms of the applicable statute or contract provision. And again, they've cited Lyman there. Lively's costs and expenses should be sharply reduced. Lively seeks a whopping $539,514.01 in costs and expenses without providing evidence to substantiate the costs or attribute them to tasks recovered by Section 47.1. Courts deny requests for costs without supporting invoices. So costs are going to be, it's going to be like this where they charge for a binder. Literally, they've charged for a binder and tabs. It'll be things like, if the attorneys have had to travel, Ezra Hudson has had to travel to New York a few times, so there'll be the airfare. In America, you charge for lunch and breakfast and taxis to take you to lunch. It's like wild. It's absolutely that's crazy. There are also things like fees and disbursements. So if you've had to pay any court fees and things like that, they're all included. The list goes on and on and on and on. But that's kind of what costs broadly look like. Okay. Lively seeks substantial sums relating to experts, even though no experts were designated in the Wayfarer action. Yes, my God, she is trying to seek recovery of the fees for the experts that she hired to prove her case. So that'd be the Darvo expert, that'd be Dina Maislin. That'd be that the experts regarding her brands and her reputation, all those experts. She's actually trying to recover the cost, even though they didn't get to discovery stage in the Wayfarer action, and therefore did not need any experts for it. Lively would have needed those experts anyway to prove her own case, right? That's just crazy that she's claiming that. Section 47.1 does not expressly authorise expert fees, consultant fees, or damages analysis expenses. Absent explicit authorization, the term costs is construed narrowly and does not include expert or consultant fees. Yeah. Further, Lively cited experts Clutter and Humphreys opined on Lively's alleged reputational harm and not on a subject relevant to Wayfarer's claim. Lively also seeks $173,276.60 in costs charged by GBX Holdings on behalf of one of Lively's retained experts for impressions and damages work. In sum, Lively fails to meet her burden to present credible evidence showing that the fees and costs she seeks to recover are reasonable, and accordingly her fee motion should be denied in its entirety. At minimum, the court should substantially reduce the request, using as a benchmark the $181,622.70 the Times sought after securing the dismissal of Count 2 on its separate motion to dismiss, the same outcome Lively achieved. I mean, I love this. I really do. And the thing is, right, is in terms of absurd filings, Lively's filing for her fees was probably just as ridiculous as our CRD. So it has been very easy for not just for the attorneys, for Wayfarer's attorneys, but also for all of us, the content creators, and many people who are watching and following this case, to just kind of pull apart and fact check her, or question things. She kind of sets herself up for some of this stuff, and it's really frustrating. I'm losing my voice again. Okay, so I'm going to have a little look at the declaration. 14 pages, so I'm not going to go through it in any great detail. I'm going to skip past the bits we already know as well. So just kind of reiterating what happened, Hi, I'm Ellen. I'm an attorney. I work for this, and then that's her background. And then it's like, this is the chain of events of what happened. Lively filed a CRD. She then filed a federal complaint. Wayfarer then filed their own complaint in counter complaint. The complaints were consolidated. The court dismissed, etc. And they're just laying out a timeline, basically. Stuff. I mean, Lyman knows most of this too. So let's have a look. This is a bit I wanted to get to, right? So here we, gone through the whole thing, where we are now, all the fee motion, etc., etc. So now we're just at the point where I think it's more important. I have reviewed Miss Lively's fee motion and attached declarations of Michael Gottlieb, and the attached declarations of Michael Gottlieb, Ezra Hudson, and Diana Kantner. The shortcomings in Miss Kantner's qualifications and analysis are described on pages 2 through 4 of the Wayfarer party's opposition. Without establishing any experience or expertise in allocating recoverable and non-recoverable fees, or providing a proper foundation for her opinions, including a showing of familiarity with the legal claims, facts, or issues relevant to this litigation, Miss Kantner separated fees into 3 buckets, etc. So we read all of this mostly in the actual memorandum that I've just gone through, which is why I'm not going to go through it in any great detail. So she's then saying that spreadsheets were prepared of 2 categories. Neither Wilkie or Manat provided billing invoices or receipts for the costs. Ms. Kantner's summaries include descriptions that do not appear to have been taken verbatim. It's just pulling apart the whole thing and reiterating what was said in the okay, this might be, yeah, so we've gone through all that. That is all there, right? Exhibit 4. In fact, you know what? Let's just look at the exhibits because I think that'd be more interesting. So this is a memorandum plaintiff, the New York Times Company. Okay, so they're attaching the New York Times request for fees in Exhibit 1. So this is Exhibit 2. This is 2.A. So this is what Wayfarer have compiled with each of the, the people who are on those spreadsheets, the timekeepers. Okay, they listed them very helpfully in alphabetical order, written down the firm that they're with, the hours that they've billed for, and how much. Right, which is really, really good work. I mean, I find it interesting that Samantha Katsy, who was the attorney who signed the lawsuit, the Van Zandt lawsuit, has actually billed for 40.3 hours. Like, what has she done for that? So Gottlieb has billed for 224 hours, which is crazy. Ezra Hudson has done even more work, 598.2 hours, which I'm not entirely surprised about because she is the California attorney and she is, she is far more knowledgeable about 47.1. Stephanie Rosa, 709.5 hours of work. Jesus. Okay, so. Okay, I get it. So. Okay. What is that? Let's just go back a minute and just have a look. 2A, yeah, 2A and 2B. Okay, the omission is material because those unsupported timekeepers include substantial billers such as Vincent Biagiotti, who billed 435.2 hours. I'm not even going to try. I'll just say Monica Lee, who billed 307.4 hours. Brent Denio, who billed 306.4 hours. And Autumn Adams Jack, who billed 178.7 hours. And Zachary Stern, who billed 153 hours. Okay, right, I'm with it now. So that's just a breakdown basically of all the attorneys and how much they charged. So these are different amounts. So I'm going to have to go back to the declaration and see what they are for. Right, so the exhibit 3, A and B are they reflect work that is performed solely in the Wayfarer action. Now that's not specifically just the defamation action, okay? That's not specifically the defamation action. That's just the entire Wayfarer action, and Wayfarer saying, well, hold on, even within the schedules that Lively characterizes as Wayfarer only work, more than 1/3 of the hours and nearly 1/3 of the fees were billed by timekeepers for whom supporting credentials, title, or rate justification was not provided. So what they're saying is look, you provided the biographies of certain, the higher billing attorneys, but the people who actually did most of the work, you did not provide any information about them, their biographies, their titles, or anything at all. Which is a good argument. It's a very good argument. All right, let's have a look at Exhibit 4. So they are picking out certain things here. It's 26 pages, so I'm not going to go through all of this. All right, but we can go back to the declaration, find Exhibit 4, and it can give us a great explanation. Exhibit 4 includes entries for attorney internal meetings, calls, and conferences. So they cite some examples. Caitlin Climaco recorded attend litigation strategy meeting. Meryl Gabernsky recorded team strategy session and com/legal call. Kristen Bender recorded attend partner call, and Miss Connolly recorded partner strategy call. Ezra Hudson also reportedly recorded entries vaguely described as legal strategy call or legal strategy meeting. So so that Exhibit 4 is a list of, examples of some of the vaguest, ridiculous entries. And this is my point, right? Exhibit 5 is going to be the point I made, right? 842.6 hours for sanctions-related proceedings, including $529,561.35 for Rule 11 matters, $289,076.40 for spoliation sanctions, and then $50,587.70 for Rule 3.6 proceedings. 3.6 is a very similar motion to Rule 11. In fact, the overlap is that they are both they're both seeking sanctions against Friedman for his statements. Both sanctions do that. She was not awarded anything for 3.6. Friedman was sanctioned under Rule 11, but Lyman specifically refused to award attorney's fees or any monetary damage, any monetary sanctions whatsoever. So she is now having a second bite of the cherry. You don't get to do that. So let's go and have a look at the sanctions. They've spent more time on this, but they've done it far more eloquently than I did. But look, sanctions motions, they've broken this down into hours and then the amount. It really helped Lyman here as well, because Lively just basically, threw the deck of cards up in the air, whereas Wayfarer have, picked up the cards and put them back in order. So this is what I did in my video. I highlighted pages and pages and pages of Rule 11 sanctioned motions, and they basically put it into kind of their own spreadsheet, which I think is a fantastic way of doing this because it clears it out. But look at this, 25 pages. This is page 12 of 25 for just the sanctions motions, and they're trying to charge Wayfarer, get them to pay these fees under the guise of we're allowed to, under Rule 47.1, we're allowed to claim this from you. No, you're not. You're allowed to claim for defending a defamation claim. That's it. But this is visually, it's an incredible way of looking and demonstrating how much Lively and her attorneys are taking the utter piss and abusing this statute, which is intended for, people who have experienced some of the most horrific things that a person can experience. This is why people like Blake Lively are dangerous. Okay, so Exhibit 6. I'm going to go very quickly back to the declaration just to capture the views of why Wayfarer put this together. Okay, so Exhibit 6 attempts to capture entries in which Miss Cantor replaced portions of the narrative with XX. Okay? XX. It's like this, right? This is an example. This is a perfect example of where they are mixing Ryan Reynolds with Lively, right? Mr. Nathan expressly recorded 1.5 hours to revise XX Rule 11 reply, in addition to 0.6 hours revising Ms. Lively's Rule 11 to reply. And I really hammered in on this entry, right? Because they've actually spent more time dealing with XX's Rule 11 reply, like, 3 times as much time. And it's annoying because the only person XX could be is Ryan Reynolds. There was no one else that they were also doing a Rule 11 reply for, the same attorneys. It could only be. And what they're saying is the redactions prevent a determination of whether the claim fees were incurred on Miss Lively's behalf or instead concerned Mr. Reynolds, other parties, other claims, collateral sanctions efforts, non-party discovery, which there was there, so on and so forth, media-related issues, Okay. Let's go back to Exhibit 6. So these are all of the entries that have XX. There is 9 pages of them, which is just utter bullshit, to be honest. Exhibit 7. Examples of vague entries. Review unidentified court filings. Attention to workflow. Litigation strategy. Sync entries. What the fuck is that? Review of complaint. 46.3 hours to review a complaint. Examples of vague entries relating to motions to dismiss. 191.8 hours of that. Are you joking? So, yeah. I'm not going to go through all of this again because it kind of speaks for itself. Review new filings in SDNY lawsuit involving clients and memorialize for team review. Just ridiculous. Oh, crap. This one, I can't. Okay, I'll just leave it there. But yeah, review filings. What filings? That's so bad. Okay. I'll probably make this the last one because I kind of. Well, no, I'll have a look maybe just at the. This is the important bit. This page. So it's where they've split up. And taken out stuff that is nothing to do with Wayfarer case, right? So the lively affirmative action. Jones Works, right? Because there was stuff on Jones Works, reviewing Jones Works. Meeting and conferring with Jones Works to strategize the spoliation sanctions. I mean, what the hell has that got to do with defending defamation? New York Times and Sloan. Okay, so and then they've put in all of the entries that do that. I think this is brilliantly done. Okay. So these are media stuff. This is just a short entry. But look, nearly $8,500 of fees just on media stuff. Who needs to do that? Nearly all of it's Ezra Hudson as well. So this is stuff like update team, analyze, attention to, index, collate, blah blah blah, review, revise. Again, more vague stuff, and this is all about largely the calendar as well. Like, organize internal case file, review litigation calendar, update team calendar. I mean, it's just ridiculous. That is just ridiculous. Attend to vendor invoices. This is so frustrating to see that. Book read of motion to dismiss. Okay. Yep. So yeah, they're just pointing out this stupid. Have I opened that one already? I can't remember. Yeah, I did. I just opened that one. Right. So this is there's travel here basically. This involves travel. I'll flick through these. I probably will go back and just see what the declaration actually says. Expenses. So travel, computer research, experts and consultants, local meals, office supplies and postage, public record searches, and other. So a lot of taxis, airfare, how come Michael Gottlieb needs lodging? And I don't understand that. There's stuff in here I just think is frivolous, to be honest. Michael Gottlieb out of town meals. When did he go out of town? He works in New York. The court is in New York. He specifically works in the jurisdiction of SDNY. Why does he need out of town meals? Yeah, so it's just the same. It's so bloated. Out of town taxi, car service, parking. Attend lively Wayfarer summit in Washington, D.C. Okay. Right. Okay. And there we go with this. Oh, okay, so they're just attaching I think this is the the way for this is the decision in the bankruptcy case, the John Mansfield Corporation, where specifically Wilkie and Gottlieb their fees were drastically reduced because they were so vague, broad, over bloated, etc. So they've attached that, which I would do a whole separate video on, just because it's interesting. I think I would just do a read through in a very short video because it's only a couple of pages, just for shits and giggles, to be honest, and to show how ridiculous Wilkie are. Okay, so we got to I think it was exhibit 5 on here, so I'm just going to no, we got to exhibit 6. So yeah, they'd picked up all the problems with the invoices and explained what they're doing, how Kantner just made a complete hash of it all. Okay, not only are the entries containing XX unduly vague, but many other entries without redactions make it impossible to determine what work was performed on whose behalf, in which action, or concerning which issue. So Exhibit 7, they just point out that it identifies such a thing. And it refers to generic stuff like workflow, litigation strategy, and syncing. They don't say whether they are related to Lively's claims, to Reynolds' claims even, or to her defences against Wayfarer, is what Exhibit 7 is there to show. Exhibit 8 shows that Lively included time spent on matters other than the defence of the defamation claim in the action. So the entries include work on Miss Lively's affirmative claims, such as opposing Wayfarer's motions for summary judgment and judgment on the pleadings, Wayfarer's answers to Miss Lively's complaint in the Lively action, FIHA issues, discovery concerning Wayfarer's investigation of Miss Lively's employment claims, and analysis of employment claims. They also show work on the Jonesworks actions, the New York Times motion to dismiss, and co-defendant Leslie Sloan's motion practice and discovery. So on and so forth. So and they're saying, look, you spent 277.4 hours, over $300,000 on this. Explain yourself, is what that seeks to do. Exhibit 9. Ms. Lively also seeks fees for non-legal or business-orientated work, including advice concerning media communications, press coverage, social media reports, and client media appearances. So notably, Ms. Lively previously took the position that media advice is not attorney work because it constitutes business rather than legal function. Yeah, it is an absolute joke, right? That they are trying to say, well, sanction Friedman not once but twice for media statements, and then they're trying to bill Wayfarer for their media statements, and what? Miss Lively also seeks fees for clerical or administrative work, including filing documents in council's internal document management system, indexing pleadings, organising and updating trackers, calendaring, preparing binders and e-binders, distributing filings, managing service lists, and book reading, i.e. proofreading. And Exhibit 10 identifies examples. Again, it's not exhaustive. Like, they've not gone through absolutely everything, but they have put together pages and pages and pages of, to reflect. I think they make their point with 185.3 hours. These tasks are administrative or clerical, not substantive defense work. Exactly. And again, they do say because the exhibit is illustrative rather than exhaustive, the total amount of clerical fees sought may be actually higher, which I think it would be. So, attorney's fees for travel time untethered to any identified proceeding or event related to the defense of defamation claim. Again, this has to be a defamation claim. If they're traveling for Lively's claim, they can't recover that. So, for example, on February 4th, 2025, Hudson recorded 10 hours in a block that included travel from New York to Los Angeles, social media commentary, calls with unidentified persons, multiple litigation work streams. On February 4th, 2025, Miss Rosa recorded 4.45 hours for travel from New York to Los Angeles, and on May 30th, Miss Hudson recorded 5.5 hours for travel from Washington, D.C. to Los Angeles. These entries do not identify a hearing, deposition, or court-ordered appearance, compensable event, or other claim-specific purpose because several are block-billed with other tasks. They may obscure additional non-compensable travel time. Ms. Cantner's billing summary shows that Ms. Lively's counsel began billing work concerning Section 47.1 fees, damages, and procedural mechanisms months before the current fee application. The motion to dismiss, which was filed in March 2025 and included a request for fees under Section 47.1, yet the records still do not reliably allocate compensable and non-compensable work. Okay, so exhibits 12A to G. These are the expenses. They are portioned out in 7 categories, but the descriptions frequently fail to identify how the charges further the defense of the defamation claim rather than Ms. Lively's affirmative claims or the broader consolidated litigation. GBX Holdings. It is clear from Gottlieb's declaration that the approximately $173,000 in costs charged by GBX Holdings were incurred for the purpose of assessing the impact to Ms. Lively's reputation, if any, from the Wayfarer action. Similarly, Ms. Cantner's summaries identify $173,276.50 in 47.1 related GBX charges and include invoice descriptions for new impressions, assembling a damages approach, 47.1 impressions collection, website and traffic analytics, calculation of impressions, figures, coding social media posts, etc., etc., etc. These descriptions reflect damages and reputation impact work, not costs that are tied to defending the defamation claim itself. She also seeks $134,500 for computer research expenses for Westlaw, Lexis, Bloomberg, and Pacer. Okay. They do not identify the research topic or proceeding to which they relate. She does not provide invoices, nor does Ms. Lively provide the firm's Westlaw or Lexis fee arrangements. Because, yeah, you pay a fee for them. It's not like Pacer where, you pay per search. With Lexis and Westlaw, you have like an annual fee or, whatever the arrangement is with the law firm. Because the law firm will have, will pay a fee for the provision of Westlaw and Lexis to the entire firm. Yeah, it's not. I mean, you individually then you go and set up accounts, but there'll be like a license to use these, which the firm will have. And unless they have a different arrangement, which is what Wayfarer are saying here is, well, hold on, you don't provide any information about the Westlaw or Lexis fee arrangements, but it is not the same as Pacer, right? It is so basically it's an archive of decisions and law. Pacer is like federal cases where you can look them up and you can search the dockets, look at motions. Westlaw and Lexis are they hold judgments and cases and you can do your research on them, but you don't have to pay for each time you search on them in the same way that you do with Pacer. Travel expenses include charges for client meetings, a strategy conference, a Lively Fees Wayfarer summit, and co-counsel meetings that are not tied to a hearing or defense-specific event. Remaining categories include local meals, public records searches, and other charges such as lunches, background searches, and a transcript fee that do not show claim-specific necessity. Taken together, the counter declaration and supporting materials show that Ms. Lively's request depends on categories of work that are unsupported, unallocated, redacted, vague, clerical, collateral, or facially connected to matters other than the defence of the defamation claim. The problems are cumulative rather than isolated. Many entries combine multiple issues, including block billing, internal strategy, communications, redactions, work for other parties or actions, media-related work, travel, and administrative tasks. The summaries do not permit a reliable determination of what amount was reasonably and necessarily incurred for the defence of the defamation claim. And then we have Exhibit 13, a true and correct copy of an order dated February 25th, 2025, in Re. John Mansville's Corporation, in which the United States Bankruptcy Court for the Southern District of New York reduced Wilkie's requested attorney's fees from $543,165.70 to $10,512.50. I suppose that's probably going to be a little bit of, a payback for that time when Lively's attorneys dumped in an entire docket for the Vin Diesel thing. It was just wild, just to try and say, oh my God, look, Friedman, he's aggressive. Over 400 pages, and the judge is supposed to just, find it himself. It was just stupid. But this is only a couple of pages long, so I will do like a little separate video where I'll read through it, and we can all have a little laugh together at how just ridiculous the grifting that is going on with Wilkie is shocking, in my opinion. Like, I feel like this is where Manat are more reasonable. But again, let's just, remember Manat, the architects of Van Zandt. The ones who put in all those potentially perjurious claims into the CRD that they were obviously concerned about because they researched perjury into the CRD. Let me know what you think of this. Obviously, Lively will have a right of reply, so that I think will come next week. I can't wait to see how they spin this, but Ellen has done a masterful job of absolutely pulling this apart. Now, yes, there are some typos and things which they don't sit well. They never do, and that's on both sides. But I think she's done an absolutely phenomenal job, and proper laid it all out for Lyman as well, with all the exhibits attached to the declaration. Where they've pulled apart that ridiculous spreadsheet and gone, well, hold on a minute, this is for unreasonable stuff, this is for more unreasonable stuff, this is for totally absurd stuff, and I like how they've done that, and I think Judge Lyman will actually like that. I don't think Judge Lyman is going to give Lively all of this, okay? Even if I was to say, well, he's given her everything else that she's asked for, I don't think he's going to give her this, because I don't think he can. I really don't think that he can find a way to give her all of this, because it is clearly not related to defense of the defamation claim against her. It's far too much of it. And he himself, I think he will be annoyed at a couple of things. One, the shocking statement that Lively's attorneys put in their motion, where they said the court has no authority or cannot apportion the fees. The court can do that. I think that's wild for them to even make that statement. But also, I think he's going to be pissed that they're trying again with the Rule 11 sanctions. They're basically ignoring his judgment there and saying, yeah, I know you denied us fees again, but I'm going to ask you again, give me fees. And I think it's going to piss him off, because that's not what reasonable people who, have been subjected to sexual harassment in the workplace bring a claim. They have some very limited success in that they can get their attorney's fees back, reasonable attorney's fees back, and then they go and try this bullshit. I think it's going to really piss him off, and he's not going to let it fly, because he can't, because it will set a precedent that yeah, you can get your reasonable attorney's fees and costs back under section 47.1. He's not going to give her then everything. He's He's not going to give her everything and expand the statute on that. All right. If you've got any questions, please do put them in comments, and as always, let me know what you think.